Hello, how are you today? This is Bong Soo-jung, Korean labor attorney. Today, I'd like to introduce one labor case related to unpaired termination. So, there is one the American subsidiary company in Korea. This company provide the after service for ERP program for many companies. So they realized that the online service for client is possible, so they don't need to hire the resident workers working in Korea. So they decide to fire remaining 2 workers in Korean entity. So in this case, this dismissed employee visited this labor law firm and asked for the legal representation for unfair termination. So I took it as a labor attorney. So I reviewed the case carefully. So there is no one working because they provide the online service from America. So I explained that the number of workers working here, even though there was 2 in last moment, but the application for unfair termination should be the workplace where there should be 5 workers or more. So in this case, even though there are only 2, but this is it's not independent entity in Korea, so the number should be calculated together with the head of office in the USA. So they are eligible for applying for remedy claim. So also they continue to work as an online service. So this termination is unfair. So I applied for this remedy claim to the labor commission. So in that case, the response from the company, they hired a law firm, and the law firm represent the company and explained the Korean entity has more than less. They have an employee that is less than 5, so they are not eligible for this remedy claim according to the Labor Standard Act. Also, company is about to close their Korean business. That was the reason why they fired all people. So that is second reason. Third reason is redundancy issue. They suffered from many years in deficit. So in order to save cost, they had to fire the people. So that is what the explanation for the justifiable termination from company side. So I, in response to their claim or explanation, I explained the Korean entity was not independent, so the number of workers should be calculated together with the head office. Also, they are providing online service. So even though they say they are going to close this business, but it was a lie. So yeah, I responded based on actual tax invoices I collected from the former workers. The third one is the managerial dismissal, but the company didn't follow the required rule there. So I explained those the answers in rebuttal document. Then company suggested for peaceful settlement. So they suggest 6 months salary compensation. So, but our the dismissed workers demanded more because the market is not good to get rehired in short period of time. So they request about 1 year the salary compensation for this termination. So settlement. So then finally we get some agreement, that is 8 months salary agreement, settlement for this peaceful termination. So both parties agreed. So I think this case is solved very smoothly based on the representation or some justifiable explanation for their claims. So I think this is something very unusual case I represented, because this is a foreign invested company. They dismissed all workers. There are no one working in Korea for that company, but through some my expertise regarding helping foreign clients, so I successfully represented those two dismissed workers. So we get to the very acceptable settlement agreement. So this is a case I represented recently. Okay, this is all. Thank you for watching. Bye bye.